I think that people generally like to oversimplify personal injury law. That person was at fault. They're to blame. But the analysis goes deeper than that. I get asked all the time how I know whether or not I have a negligence claim. Honestly, I don't think the way that we learned it in law school is all that difficult for the general public to understand. There are 4 elements of negligence. There's a duty of care. Did the person you're alleging harmed you have a duty to keep you safe? Did they breach that duty? So did they do something wrong? Did their breach of that duty cause you damages? So duty, breach, causation, and damages. In order to recover for a negligence claim, you've got to be able to prove all 4 of those. So the way that the courts work is effectively based on precedent called the common law. And what a judge will do in deciding issues of law is look back at all of the precedent from the last couple hundred years and determine whether or not you have a viable claim. So here's an example. This is a famous case taught in law school called the Palsgraf case. So a guy is getting on a train and the train conductor or an employee of the train company helps this person get on the train. In getting on the train, this person's backpack falls to the ground and there's a giant explosion. Apparently this person had fireworks in their back. And somebody all the way down the platform gets hurt because of something falling from the ceiling due to this explosion. And what the court ultimately said was, there's no way that the train company could have reasonably foresaw in helping this person that they would have caused those damages. That is not reasonably foreseeable from a causation perspective. And so those are the types of issues that courts will look into if you have a claim that is just outside of the norm. Either way, it's going to be very fact sensitive, and determining who's at fault is going to come down to, were there witnesses that saw this? Was there video footage of the accident? What evidence are you going to put up to prove that you were injured due to somebody else's negligence? Now, keep in mind, in proving negligence, it is the plaintiff, the person bringing the claim, that has the burden of proof. So the plaintiff has the burden of proof. They have to go before a jury and argue that person is at fault for what they did. They present their case. Theoretically, and you do see this from time to time, when they call the defense to put on their case, the defense can stand up and say, we don't want to say anything because the plaintiff has not proven their case and therefore they cannot recover. And so, if you have any questions about this stuff, you absolutely should consult with a lawyer. They'll be able to help navigate whether or not you have a claim.